boys were accused of making an obscene phone call was about to reach the Supreme Court of the United States. Amelia Lewis feared she lacked the experience in constitutional law needed to win the case before the U.S. Supreme Court, so she enlisted the aid of Norman Dorson, a professor of constitutional law at New York University. In presenting their case to the court, Mrs. Lewis and Professor Dorson again argued that under the 14th Amendment to the Constitution, juveniles accused of crimes should have many of the same rights that adults have. These rights included proper notification of what the juvenile was charged with and when hearings will be held, the right of an attorney or to have an attorney appointed by the court if the juvenile cannot otherwise afford one, the right to confront and cross-examine witnesses, the privilege against self-incrimination, the right to have a transcript made of the proceedings, and the right to appeal juvenile cases to higher courts. For its part, the state of Arizona argued that the juvenile justice system was designed to be non-adversary. Proceedings were informal and didn't involve lawyers. The state was interested in what's best for the juvenile, not in punishing him or her. Since this was the case, the state argued that the Arizona Juvenile Code already provided adequate protection for juveniles accused of criminal activity. The Supreme Court heard oral arguments on December 6, 1966, nearly 2.5 years after Re Gault was first arrested. It would be another 6 months before a decision was announced. Finally, on May 15, 1967, the Supreme Court released its decision. The Gaults had won on nearly all counts.
I was in Park's Dog Course Center, crashed out on bed, where I like to be, and they called me up to the Superior's office. My counselor called me up to his Superior's office. I guess you'd call him the Dean of Boys there. And he says, you just won your court case. I was going to have newspaper reporters and newsmen there. Wow. I guess this is going to, why are they coming? And it says, to interview you, because you made this big court case, and you went all the way to the Supreme Court. Juvenile cases don't do that. So I said, wow, guess one did.
The United States Supreme Court decided that children should have, in all proceedings, the right to adequate and timely notice, as should their parents. That they should have the right to be told that they can cross-examine the witnesses against them, that they have the right to call witnesses, and that they have the right to have subpoenas issued for that purpose. Most times, witnesses will not come willingly, so you have to subpoena them. That they have the right not to testify against themselves. They have the right against self-incrimination. That they have the right to counsel of their choice. And if they cannot afford it, counsel will be provided for them by the state.